every one of you a great speech. The greatest speech of your life. When I say that you are going to make a great speech, I recognize full well that there are those among you who say, wait a minute, I'm not a great speaker. I don't know how to make the great speech. And there are just too many things to keep track of. Enough. Ooh, can you hear me in the back?
Yeah.
Okay.
Yes, sir.
Too many things to keep track of as I make this great speech. But I can tell you that I do know something you don't. And that is that each and every one of you are capable of that great speech, the great closing argument tomorrow. Wherever around this nation I have asked people in similar situations to yours to make that great speech the next day, they did it. There are ways to make it so that you can do it. One of the great difficulties we had is that we went to law school. When we went to law school, every time that you recited, the professor was ready to jump down your throat. You were trying to keep all kinds of balls in the air. You were trying to keep track of your notes. You were trying to keep track of what was going to happen to you. You wondered of what was happening to you with your colleagues. Tomorrow, your number one priority, yes, we can have some other additions to your closing argument, but your number one priority is going to be spontaneous, natural, to be connecting with the jury, to take off the handcuffs and the shackles that have been placed upon you when you try to keep track of so many different things. What the experts tell us is that you can focus on only one thing at a time. You can switch back and forth. But what happens when you do that? When you're switching back and forth about your notes, about exhibits, about what's going on with the other people around you. When you are doing that, you have so many balls in the air. It is like you have 100 units of energy to put into connecting with that jury. If what happens is that the major process is going from here to here, trying to figure out what's going on, what should I say next, I don't want to forget, all of those things make it impossible for you to put your energy, 100 units of that energy, or as close as possible, to connecting with your jurors. But we're going to talk about how it is that you can do that, and I tell you at the start that I know that every one of you can. Let me talk just a little bit about closing argument to put it in perspective. There are those who say, if you haven't won the case, by the time you get to closing argument, you're through. And I say that those people do not know how to make a closing argument. If all the cases that went against me, that were against me at the time the closing arguments began, nobody would have invited me here because I would have been a loser. There are powerful devices that some of which we're going to talk about, that you can use in closing argument. One of the devices that I hope you're not going to do is to do what is called the storytelling closing argument. And I want you to know that we have been emphasizing storytelling to you up until today. Fair? It's storytelling, storytelling, storytelling. And here I am, ready to suggest to you that we are going to shift gears. Tomorrow, we are not going to tell a story. Tomorrow, we are going to argue. This is a very different subject. And I want you to know that I am in complete agreement with all the storytelling techniques that you have been gathering during this time. If I were talking about opening statement, I would be talking to you about opening statement. Because I suggest to you the most powerful way to win a case is to paint word pictures making your points on that opening statement. But then when you get to closing argument, you don't want a rehash of that opening statement. You want to approach the same issues, but in a different way, through argument, to show why your story is the better story. So, I want you not to make a storytelling closing argument tomorrow. There are other closing arguments that I don't want you to make. The reasonable doubt closing argument. And this, ladies and gentlemen, is reasonable doubt number 7. Let's talk about reasonable doubt number 8. We'll talk about the powerlessness of that kind of argument in a little bit, but that we don't want. Another kind of closing argument that I want to take away from you is the closing argument where we get up and it's a soup. And this happens over and over again. That closing argument is one long, not organized into particular issues, not organized into particular argument points, but it is, the points are kind of strewn together, and there are no pauses, no paragraphing, no separating it into organizations. I'm not talking about something that just occurs once in a great while. Folks, I watch closing arguments in court, and this occurs all the time. If I took an audio tape of one of those closing arguments and handed it to the secretary, and she says, "How do I punctuate it?" And I say to her, "Punctuate it the way the attorney did, as the attorney spoke." What would happen is that there would be one long paragraph of interspersed arguments. We are going to have a better organization than that. The legalistics closing argument. We went to law school. We know that we can speak legalese. We know that we can throw out these legalistic terms one after the other. And we are impressed with ourselves. Unfortunately, we are not on the same page with the jury when we're doing that, because jurors do not think like lawyers, and lawyers do not think like jurors. We went to law school and we were taught to what? Think like a lawyer. What did they mean by think like a lawyer? They meant think like the law professor, right? They meant that they were going to spend 3 years taking any humanity, any soul away from you if they could possibly do it. And if they succeeded, then you would be one who thinks like a lawyer. That's fine for legal analysis, for legal research, but that is not fine when you are talking to a jury, because the first rule of persuasion is that you must know your audience, and the second rule of persuasion is that you are going to be on the same page and appeal to the belief system of that jury. You can't do it and be thinking like a lawyer. Now let's talk a little bit about going to work. What are we going to have during that closing argument? First of all, We need to take all the materials, incorporate all of that you have been gathering there during this 2 weeks. Yes, our closing argument is going to express the theory of the case. Our closing argument is going to have themes. The major theme, the overriding theme, is going to be not that the prosecution failed to prove each and every element beyond a reasonable doubt. When I say that, what am I implying about what I think about this case? Let me try it again. Let me pick on you as the prosecutor, not because you have any tendency along this line. I say the prosecutor failed to prove each and every element beyond a reasonable doubt. Do I, the attorney for the defense, believe that Johnny is guilty or innocent? What do I imply when I say that? This is news to me that defense attorneys are implying to the jury that Johnny is guilty, but you should let him off. Why? What is this great, powerful reason we should let him off? Because this prosecutor failed. That's a reason to let Johnny off? I am not saying that you don't use reasonable doubt, but you use it in a very limited way. Every time you use it, it is connected to the concept that Johnny is innocent. The reason, why, dear, at the end of the case, that we have the rule about having to prove the case, the prosecution having to prove the case beyond a reasonable doubt, is what? You're well-trained lawyers. Come on, human.
The innocent aren't convicted.
Well, how about protecting against the conviction of innocent persons? Because what we know about our jurors is that they are common sense people. They're in there to decide whether Johnny should go south or home. Only, and this is the real test, only if they are afraid they can't sleep tonight if they convict are they going to let Johnny go home. And so our big objective during the trial is not any kind of legalism. It is to scare the hell out of the jury about the possibility of convicting an innocent man. When you try cases this way, you win and win and win and win. Notice what I'm talking about. I'm talking about a way, instead of the major argument, which I know it is around this country, I know that many here use it as their central theme: the prosecutor failed to prove each and every element beyond a reasonable doubt. You win a lot that way? The answer is no. When I was in the public defender's office, because I took the position, what? Not that the prosecutor failed to prove, that wasn't my central theme. I mentioned it in connection with protecting against the conviction of innocent persons, but my central theme was that Johnny didn't do it. They got the wrong man. They didn't conduct the kind of investigation they should have done. Judy Dodd didn't tell us the truth. More powerful than the legalisms? Does it pay off in wins? Yeah, I won many times what my colleagues who were involved with the legalistics did win. A central theme of the case is going to be that Johnny is innocent. The story from which you are making this argument is the story of innocence, which you put together when you put your case together first. What is a theme? Well, it's a kind of a nebulous term, but it's something that you use over and over again. repetition is the hallmark of the theme. Why would we want to repeat points, either in the same words or the same intent? Well, the advertisers understand this, don't they? They know that saying something one time has very little effect. What we know also is that the jurors remember less than 10% of what goes on in court. That they have a span of attention, some people will say, of only a minute and a half. And so they're not even listening. And so we must take our central themes and come at them over and over in different ways. I remember a case that Larry Posner had. He's the Larry in Larry Rench. Okay. Larry Posner had, and it was self-defense. There were 4 or 5 guys, and his guy didn't shoot one of them. And his theme was, and nobody would help. And nobody would help. And nobody would help. And nobody would help. To win the case, of course. So we are going to be developing these themes from day one. We, of course, are going to take the evidence that you have accumulated during this 2 weeks, the demonstrative evidence that you have accumulated. And then the great thing about closing argument is that you have something additional for closing argument. You not only argue the facts, but what? All reasonable inferences therefrom. I have made a career of these all reasonable inferences therefrom, and I suggest it to you. We usually don't disagree with the evidence, with the great majority of the evidence presented by the prosecution. The difference is that we are going to give a what? An innocent interpretation of that evidence. We are going to connect the dots consistent with the innocence of Johnny. So let's never forget, all reasonable inferences therefrom. It is your path to creativity. It is your path to winning case after case. Choose powerful arguments. Powerful arguments for whom? For your fellow lawyers? I mean, any of them are going to sit on the jury? You're going to choose powerful arguments for the jurors who have 2 objectives, basically. Truth and justice. This is what they are about. That is the reason I suggested to you a while ago that we have a story of innocence. That we have our arguments with the central theme being innocent. Because the jurors, if he is guilty, want to find him guilty only if he is innocent. And therefore we are on the very same page with the jurors when we take the position that he is innocent. Now there will be legal scholars among you who will say, that's assuming a burden which we do not have to assume. At NIDA we have cases that are tried, and then we watch the jurors deliberate. I've probably watched 70 hours of deliberation. How often during those 70 hours do you think that I have heard them discuss who has the burden of proof? None. None. Jurors don't think like that. When you are thinking about proceeding legalistically, we have to realize something. This is our way of doing legal analysis. It is not the way we even think when we are not lawyers. Who has a 4 or 5-year-old? Name.
Kian.
Kayon? Okay. So, you have a friend who's going to get married soon. You bake a cake. You get your friend Dora, who is a decorator of the highest order, to decorate this cake. The guests are going to arrive at 8 o'clock. At 7 o'clock, there is a handful of the frosting. And you say, Kayon, did you get into the frosting? And Kayon says, you can't prove it. How is that laughable? I mean, this is the way we think as lawyers all the time and assume that lawyers think. Well, I happen to know you're too nice to do this, but you would be inclined to take Kayon and knock Kayon right through the wall. If there's one lesson, it is that we are going to prepare our closing argument for the jurors who are not lawyers, and not for our fellow lawyers, not for the judge, and not for the law professors. We are going to use powerful arguments. Now let's talk about the closing argument. The first thing, the beginning, is the hook. Not the closing. It is. We've been here for 2 weeks. It is now time for us to listen to closing arguments, and the purpose of none of that. The hook is going to follow the same kind of theme that I'm talking about. It's going to be on the same page with the jurors. And I can tell you, if it's going to be on the same page with the jurors, that hook is going to have a morality dimension. Plays are, or rather, trials are morality plays. The jury, the social psychologists tell us, when they have an equity theory, that people desperately want to do what? The right thing. That's what they want to do. If there is a choice between doing the right thing and some legalism, the legalism falls to the side. So if you are going to depend on a legalism, then what you must do is to make it so that following that legalism is doing the right thing. It must be that the jury understands the morality that is behind, the moral compass that is behind the legal concept that you are talking about. So at the beginning, we're going to have our hook. It may well be that at the end, when we are engaged in our final appeal, that our final appeal is an echo of, and echo is a rhetorical device, by the way. It's going to be an echo of our hook. Now then, let's talk about that which I want to talk about. That wasn't quite where I wanted the emphasis. Arguments. Argumentation. Arguments are a different field. Overlap, yes, but they are a different field from storytelling. When you are arguing to the jury, it is an argument. It doesn't have the same tone. It doesn't have the same tempo. It doesn't have the same volumes. It doesn't have much at all. You recognize what is a story and what is This whole field of argumentation is in the library. It's not far from storytelling. As a matter of fact, go to Dewey Decimal System 808.5 and you will find oratory, you will find power of argumentation, you will find that these two things are close together but nevertheless separate. Now, we want to talk about arguments in terms of argument. How are you going to organize? How are you going to organize your closing argument? And I suggest that this is the way you're going to do it. At the hook, you are going to have looked at your case for the CCIs, the crucial contested issues. Crucial because he and I are fighting about them and it's going to make a difference in the case. Contested, we are against each other. These are the issues which the foreman of the jury, if he's appointed just before the break, is going to make a list of for that jury to decide. They are the issues which are crucial, contested. And guess what your arguments are going to be? They're going to be the argument points on your side of each one of the crucial contested issues. This making sense? We are going to home in on the same page as the jurors, on the same page that we believe that they are looking for their issues. And once we do that, we are going to prepare an argument for each one of these. Now, I mentioned a while ago a form of closing argument that I see with regularity, and that is where it's all mixed together. What we are going to do is to take each argument point, and I know that you've talked about chapters. They are going to be separate chapters. Now then, these are not subjects of discussion. Like, ladies and gentlemen of the jury, I want to talk to you about Judy Dodd's credibility. Powerful stuff? No. We are going to tell the jury that Judy Dodd didn't tell us the truth. I'm going to talk about power language in a little bit. But do we notice that there are powerful ways to say things and there are weak ways to say things? We are going to state these issues on our side. Now, how is it that we are going to be able to organize to give the great speech? Because as to issue number one, our argument number one, we are going to have a chapter. And there is going to be a transition, a pause, a movement. You are going to let the jury know that you are moving on to argument number two and argument number three. Now, let's talk about how you organize a particular argument. That Judy Dodd didn't tell us the truth. This is how you can put together almost any argument that you ever make. And you're going to keep these arguments separate, by the way. It's easy to remember when you are making this point, and you don't have to worry about anything else at the same time during your closing argument. But first of all, you are going to tell the jury what the point is. I can't tell you how many times as training director in Colorado, my trainees would get up and give a whole bunch of facts. And I would say, you know all these facts, but the jury didn't even understand the point you were making. And you know what the trainee would say to me? But it's obvious. Yes. Obvious to someone who has spent hours, weeks, months working with the case. But there's another advantage to it, and that is by telling them what the point is, it becomes a theme, doesn't it? Each one of your points becomes a theme. Now what we're going to do, after we have told them what it is we are going to develop that point. How are we going to develop that point? We are going to marshal the evidence. We are going to put our themes in here. We are going to put our inferences in here. We are going to put whatever it is that supports this particular point. Why not scatter it out during the closing argument? One of the great devices that you learn from the argumentation experts is that we don't scatter stuff out. What we do is to concentrate. We put it all together. Two devices that I'll mention now. One is juxtaposition. We are going to take every single fact that makes the point that Judy is not telling us the truth, and we are going to put them right next to each other. If there would be 5 persuasive points that would come from 5 things scattered throughout a closing argument, if you put them together one after the other, it will be 25 PowerPoints that you will have. That is such a tremendous device to concentrate that which is scattered and put it in one place, all together. I'll give you another device that helps, and that device is enumeration. These are devices that if you study argumentation, you will find useful over and over and over again. There are 5 facts that demonstrate that Judy Dodd is not telling us the truth. 1 enlisted, 2 enlisted, 3 enlisted, 4 enlisted, 5 enlisted. Let's talk about them one at a time, ladies and gentlemen of the jury. Okay? Look at the power you get from doing this kind of thing. Enumeration, will they remember all 5? No, they won't remember all 5. But they will remember that there was a bunch, and they were all concentrated. So you're going to take every single thing that fits under the point Judy Dodd is not telling us the truth, and we are going to put it in this development phase. And then, as to that particular point, because you see what we have is a mini closing argument on each one of the arguments, separate and apart from the others. We are going to close. How many of you have been in sales? What's the most important part? Yes, close. We're going to close the deal. And if I don't have any other way to do it, at the time I come to that place in the closing argument, I'm going to slow down and say, thus, ladies and gentlemen of the jury, we have shown you 5 facts, separate and apart facts, that demonstrate that Judy Dodd is not telling us the truth. Then what? Pause. What is your objective? This is all about persuasion. Go to the library and read about persuasion. Everything I'm saying is there. It's not mine. Why are we going to pause? Because we want that jury to think about the fact that we just gave them 5 facts that demonstrate that Judy Dodd is not telling us the truth. And it also signals to the jury that we are going to go on to another point. What happens when we just go along from point 1 into point 2 without telling the jury? They are on point 1. Well, we're way into point 2 before they understand. So we are going to keep those jurors organized. We're going to keep ourselves organized, and we are going to let them know what point we are making at any particular time. There are many more, but I want to mention 2 things that are helpful here. One is that we are not going to contaminate our point. Our point is that Judy Dodd is not telling us the truth. Why am I saying this? Because you all are intelligent people, and the people I've watched doing closing arguments are intelligent people, and this is what happens to them. They are making the point that Judy Dodd is not telling the truth, and some brilliant thought strikes them about another point. Fair? We all been there? Including me? Yes. And so we don't want to put off this informing the jury of this brilliant point, and so we tell them, without telling them that we are interrupting our point about Judy Dodd. And they don't understand what the heck is going on. Why should they? And by the time we get around to getting back to this, they're already on the next point. So we are going to keep those jurors on point by keeping ourselves on point. Furthermore, in this particular point, we are going to furnish the jury with road signs. When we give them 5 facts that demonstrate that Judy Dodd is not telling the truth, when we get to about the 3rd one, we are going to say it over again. And the 3rd fact that demonstrates that Judy Dodd is not telling the truth. Is this powerful? The answer is yes, because this becomes a theme. And furthermore, count on it, so the psychologists tell us, our jury has wandered off and are thinking about the dog and dinner and lots of other things. So you want to keep them with the road signs on this particular point. Let me tell you about argumentation. I wish we had hours and hours and hours to deal with it. Those of you who want to go beyond this 2 weeks, go to the library and read about the powerful devices that the debaters know, that the storytellers don't. Now, what I want you to do is to recognize that being a trial lawyer is multi-dimensional. There are lots of skills involved. A tremendously important skill, and one that I have done my best to steal from every one of the drama people, is every drama device that is useful to the trial lawyer. But the debaters know something too. The debaters know how to be powerful in court. The debaters know how to attack. The debaters know how to refute. The debaters have powerful devices that are available to them for closing argument that the storytelling closing argument does not have. And then we want to do the final appeal. I want you to have a hook. I want you to have a final appeal. That final appeal is after you have finished the arguments. And by the way, it says in the instructions that you have 15 minutes tomorrow. You are not going to be able to make a detailed closing argument in 15 minutes. So what you do it the same way that you would do it if you had 30 minutes or 45 minutes or whatever you would take. In other words, don't skip. But do have a hook, do have an argument or two, at most 3, and then have a final appeal. What's this final appeal? It may be an echo of the hook, but it's going to be that which is going to scare the hell out of the jury about the possibility of convicting an innocent man. That I guarantee. When I was in a public defender's office, I had a form final appeal for those instances when the evidence finished at 2:30, the judge told the jury to go down and have coffee, seek counsel in chambers to do the instructions, and we're going to give the closing argument this afternoon. Okay? And it went something like this. I talked to them a bit about the instructions, tell them that I'm not going to go over all the instructions with them. Tell them that there is one instruction, and here's where reasonable doubt comes in, but notice that it's always connected with the fear of convicting an innocent person. Ask the jurors to see what it is about the reasonable doubt instruction, and then the final appeal. Say to them, that instruction, as a matter of fact, every single thing that we have done during this entire trial has been for one purpose, and one purpose only. And that is to ensure that no innocent person is unjustly convicted. That's all I ask you. That's all Johnny asks you. That when you finish your deliberations, that you can say in your heart and in your conscience that no person has been unjustly convicted. I know you do the right thing. Thank you so very much. Now, those of you who are taking it down, I've never seen anybody, okay, you're not me, I'm not you, but come up with your own. You have it in your heart, in your soul, the one that is going to scare that jury about convicting an innocent man. But I want to talk to you about delivery. 76%, so the studies show, of persuasive power comes from the presentation, the delivery. Only 24% from the substance. If that is so, we want to be good at delivery. What kind of delivery are we going to do? And I asked you to do at the start the great speech. What kind of delivery does it take? What kind of notes, etc.? First of all, don't try to write it out, memorize it, say it in the mirror and all this kind of thing. Don't have it when you go in to give that closing argument that the real preparation is down here. Where must the real preparation be? Yes, it must be here. All the notes that you need are what I call job notes or trigger notes. Just enough to glance down. It tells you what point to make. And incidentally, when you've finished doing that, you probably don't need those notes, and you're probably not going to refer to them. Extemporaneous means that you are prepared, you are organized, but you are going to, when you get to the argument that Judy Dodd didn't tell you the truth, are you going to have it memorized? Are you going to have it word for word? Are you going to be thinking about what's down here? And if you are not going to be able to connect with the jury. So what I beg you to do tomorrow, priority number one. There are other things I've told you about, other devices and so forth. the one thing that I want to see each and every one of you accomplish, because I want you to feel this before you go back home, and that is the feeling that comes from knowing what the point is, having thought about it, and then letting it out, letting it flow. Letting it be natural. Let it be spontaneous. You are not choosing the words now. I guarantee you the thoughts will be more powerful. The words will be more powerful if you give yourself the freedom to do this. So I'm asking you to take off these handcuffs and these shackles tomorrow, and your number one priority is to have this energy to connect with the jury. And you say, well, this may go wrong. Well, faculty, if it goes wrong tomorrow, it's not their fault. It is Steve Rench's fault, because I am begging you. I am begging you to experience what happens when you are connecting with the jury and it's coming from your heart and your soul. And you are making the case. This powerful message for Baker and Brand and Dodd and Kitchens. I won't take the time to do it, but if any of you ask me how in the next 2 weeks you can improve 40% over the vast improvement you made during these 2 weeks, I would tell you go to the bookstore or go to the library and get a book on the rhetorical devices. These are so powerful that you can become President of the United States by mastering this, and they are easy to do. It is power language, and it is power language that the debaters are good at, and it is power language that those who give great closing arguments are good at. I don't ask you to be trying to accomplish all of this tomorrow, although it would be great if you did. But that's for the future. Next week you go to the library, check out a book on the rhetorical devices. Juxtaposition and enumeration were two of them. You know about the triples. You know about things like anaphora, whether you've ever heard of it or not. They didn't do A, they didn't do B, they didn't do C, they didn't do D. That is several sentences in a row with the same first words. All kinds of devices that I would be talking to you about that I don't have time to talk to you about today, but that you can use it to learn in the future. The choices. You're going to have it easy because I'm not going to be able to get to them. Choices. So many choices in volume, tempo, location, feelings. And in 15 minutes you're not going to have to worry, but when you get back and you're going to give a 45-minute closing argument, you don't want it so that you are on automatic pilot doing everything with the same speed, the same tempo, the same volume, with the same feeling. And this is what the vast majority, I mean 99% of attorneys do when they go into court and give a closing argument. It is the same tempo, the same volume, the same feeling from the same location, if you count pacing back and forth as a location. What you need to do is like music. You need variety to beat the span of attention problem. You need it so that if you're attacking and you say what the prosecution did was to go down to the state penitentiary and buy the testimony that they put on this stand. Okay, was there a certain volume involved there? Was there a certain tempo involved there? Was there a certain feeling involved there? Was there a certain location involved there? And when you get those 4 down, give me a call. I'll give you some more. Okay. And now, ladies and gentlemen, I want to talk to you a little bit about how Johnny felt when he was arrested for a crime which he did not commit. Does this have a different tempo? Does this have a different volume? Yes, a different feeling. So you want to work on variety? This is not for tomorrow, this is for the future, but you've got to be able to do that and not be so that you're just on automatic pilot. The self. You are your defendant's most powerful instrument in almost every one of your cases. This is not something that I'm saying. A fellow named Aristotle said it some 3,000 years ago. Ethos. Your credibility, your character, your believability with that jury, so vitally important, and you're going to keep it that way during closing argument. You are going to be a true believer, because you know the greatest witness for Johnny is going to be what you have to say, that you are saying he didn't do it. So you are, in almost every case, the most powerful instrument for the defendant, if you are a true believer. If you're thinking like a lawyer and have no feeling, no appropriate emotion, the jury feels that you do not care. And so we need you to be a true believer. Now, I've asked you to give the great speech tomorrow. There's something I know that I've learned from the other places where I've talked to people like you. I know that the next day they are able to give the great speech. They are able to put their heart and their soul into that closing argument. Let me speak to you, if I may, and I know it's a group setting, individually. I know that you may have doubts about your making that great speech. I have no doubt about your making that great speech, because I know that you can. What I have to convince you to do is to risk failure. But you see, I know you won't fail if you've got your heart and your soul into it. So I ask you to risk. I ask you tomorrow to dare to be great, because I know